Hi, everybody. My name is Sarah Stemmer. I'm the founder of Stemmer Law, a law firm focused on all things copyrights and trademarks. Today, I wanted to talk about 8 big reasons to file a trademark application. I have an article on our blog at stemmerlaw.com which lists way more reasons if you're curious to hear more, but these are my big 8. So let's dive right in with number 1. It will act as a deterrent. Someone seeing your brand on the United States Patent and Trademark Office or USPTO trademark registry will let them know that you are serious about your brand and intend to protect it. If you do end up having to reach out to somebody and let them know that they need to stop using your trademark, having a registration to show them is a huge benefit. They will take you way more seriously. Number 2, retail anti-infringement services and brand registration. Online retailers such as Amazon.com or Alibaba.com actively monitor for infringement and counterfeiting. Activation of and participation in these services generally requires a trademark registration or application. The big one, the Amazon Brand Registry, will look for a national registration or application before including you as a store on their site. If you are a seller of goods and you want to be on Amazon.com, it's best to just get this taken care of earlier so you don't have to wrestle with them too much. Number 3, the U.S. Customs and Border Patrol CBP Registry. If you are a company that produces goods, you could include your trademark on the CBP registry, which will trigger them to monitor shipments into the U.S., checking for counterfeits of your goods. The CBP will place only registered trademarks into their registry. Number 4, it will make your company more valuable and seem more legitimate. A company with a book of registered intellectual property will just simply be worth more. Whether you keep your company closely held and maybe eventually retire and sell it, or grow it from IPO to IPO, there will likely come a time when a higher company value leads to more money for you and the company. And it'll likely be a selling point to investors, which can be a really important step to the beginning of your journey. Number 5, a leg up in litigation. There's a few considerations with this one. The first one, a really big thing in litigation is the presumption of validity that comes with the trademark registration. If you have to go to court to stop somebody from using your brand, having a registration, the court will have to assume that the trademark is valid. It will then be up to the other side to prove that wrong, which is super challenging from a legal perspective and ends up being a ton of work for them. The second part of litigation is it makes cancellation and oppositions at the USPTO Trademark Trial and Appeal Board a lot easier for you if you're trying to cancel somebody's trademark or oppose the registration of it. This is where a registrant or applicant can file a petition to stop the USPTO from allowing somebody to have a registration for that trademark. The third part of this is access to UDRP dispute resolution. If someone registers a top-level domain like .com, .net, .org, etc. with the intention to infringe on your trademark, if you have a trademark registration, you can use the Uniform Domain Name Dispute Resolution Policy, or UDRP, online and stop them. And having the domain transferred to you is one of the results, which is really cool. So number 6, protection for your product once your patent expires. Once a patent expires, a trademark can help trademark owners retain their customer base through the goodwill and trust that comes with the brand. One of my favorite examples is with the tiny bricks maker Lego. When their building block patent expired, the imitators were so successful that Lego almost went out of business. But they managed to get past the initial blow and stayed afloat with the help of their trademark that we all know, Lego. Number 7, there is such a thing as incontestability. So I mentioned earlier that the Trademark Trial and Appeal Board, or TTAB, is a way for people to challenge your registration. Well, after 5 years of registration, a trademark owner can file what's called a declaration of incontestability, which will cut off most options for someone to cancel your trademark, which, I don't really need to explain it anymore. The fewer reasons to cancel your trademarks, the better. Number 7 leads us to number 8, which is the last one, and it is kind of a nightmare scenario, but does happen sometimes. Say you use your trademark for many years without filing an application. And in the meantime, unbeknownst to you, someone with a similar brand has been registered and does achieve incontestability status. You will no longer have superior rights to them, and they could force you to stop using your trademark, even though you came first. Filing an application and you filing for incontestability before anybody else can keep your trademark safe. Well, I hope this has been helpful and helps you to understand the value of having a trademark application in the system. Hopefully we'll be registered one day. If you need any more insight, you can reach us at stemmerlaw.com.